should perhaps get started. Good afternoon, everyone. Thank you so much for being here with us. We are so excited to host this lecture and to talk about something very topical and very important. So my name is Yusra, and together with my colleague Claire Cummings, we run the Climate and Justice Group, which is an interdisciplinary group of academics, mainly between the School of Social Sciences and the SEED. And we bring together our interdisciplinary expertise across the humanities, and we essentially do that to develop knowledge and research into how law and regulation are shaping the struggle for climate justice. So this is a network that consists of about 30 researchers spanning different schools across the humanities. And we've had a series of events throughout the course of the year, mostly small seminars for us to engage with each other's research. But it's with enormous pleasure that we are organizing a public lecture to engage more widely with students and other staff members and the wider community as well about this very important research agenda. And so for our public lecture, it gives me so much pleasure to introduce Paul Clark, who is with us today. He is a seasoned barrister at Garden Court Chambers in London. Paul provides representation and advice in public, civil, environmental, and international law. Most relevantly for our lecture, he is an established practitioner in the field of climate justice, both international and domestic. He acted for the applicants in the groundbreaking case of Duarte Agostino and others versus 33 states. That was before the European Court of Human Rights. He has also acted in other very prominent and high-level climate justice-related cases. He was named Times Lawyer of the Week in 2023, and having appeared before the International Court of Justice and several of the international criminal tribunals, and also having worked at one of the former international criminal tribunals, he offers a unique expertise in general international law that forms a part of his practice in climate justice. So without further ado, it gives me enormous pleasure to welcome and introduce Paul Clark.
Well, thank you very much indeed, Yusra, for that incredibly kind introduction, perhaps too kind, given the outcome of Duarte Agostino as to its groundbreaking status, but I'll come back to that. So, you've perhaps seen the flyer and the abstract. By way of introduction, it's a feature, I would say, of contemporary governance generally and campaigning, that courts are seen as holding hope for justice, where the other two branches of government, Parliament and the Executive, have failed. This impulse to make use of the courts and the optimistic reason for it is as much a feature of politics at the global level as it is at the domestic level, and this applies to the question of climate justice particularly clearly. In this seminar, I aim to examine the effectiveness of law, the courts, and of lawyers in pursuing this perceived potential. Now, I'm a practicing lawyer, and as such, I will stay in my lane. I don't aim to draw broad comparisons between all approaches to effecting change and pursuing justice, but I'm not myopic, and I'm not trying to ignore other means of pursuing social change. I simply don't attempt a survey of what works best as a strategy for social change by comparing litigation with other strategies. That would take far longer than a short seminar like today's, and you may well think, with justification, that a lawyer would be the last person you want to hear from on the question of social change. Rather, I aim to highlight two particular features of the turn to the courts in the context of climate justice: the invocation of human rights and the invocation of the criminal law, and to consider whether the use of the courts in these contexts really offers the hope that it may seem to. So let me begin by raising a simple question. why go to court at all? It's clear to everyone that climate change is a global problem and it's best resolved collaboratively and multilaterally, you would no doubt say. We need every state to be at the table, bigger states and smaller states, coming to an agreement on what to do, which is aligned with the best available science and with climate justice. Now, I emphasise the distinction here, although I'm not only going to speak to the question of climate itself, but the distinction between environmental harm generally and climate change, and in particular the specificity of climate change in this regard, which is a corollary of the very nature of gas, the inability to trace specific emissions to specific harms. Now, a consequence of this feature of climate change, which is not an aspect of all environmental harms, is that the first two questions are these. Number one, how much is a safe level of emissions overall? Well, compatible with 1.5, you might say. Maybe we'll come back to that. So what is the safe level? That's the first question. Number two, how does each actor, whether that's states, corporations or individuals, comply with that overall requirement? And by that I mean, how do you share out the burden? How do you know when a particular actor is not acting in a way which is compliant with the overall limit? In some senses, these are not the only two first questions. We might suggest a third, which is the question of compliance and enforcement. But that is really just a practical implementation of the second question. So the need for focus on these questions is not only essential, it's also extremely urgent. Even the 1.5 limit, if we were to achieve it, and that's looking increasingly unlikely, is not a good outcome. There is uncertainty along the way as well, and this is something which isn't acknowledged frequently enough in the form of tipping points. Who knows what might happen when thresholds are met along the way? It may be that a threshold way before 1.5 renders things that come after it inevitable. Now, this is a multilateral problem, and the courts, you might say, are not at all suited to it. And that idea is based on a traditional view of the courts, essentially as the body of government which applies predetermined rules to specific circumstances. And to an extent, the multilateral approach was, of course, the intention of climate change. If you look at the blueprint for cooperation, you can say it was created in 1992 with the UN Framework Convention on Climate Change, with a strong objective preventing dangerous anthropogenic interference with the climate system. And then you have Article 2 of the Paris Agreement, which says that the agreement will be implemented to reflect equity and the principle of common but differentiated responsibilities, I really emphasise that, and respective capabilities in the light of different national circumstances. But this has been a failure. The meaning of common but differentiated responsibilities is heavily contested. And if the objective of the Framework Convention had been met, if states had done what they needed to actually achieve that objective, then no proceedings in relation to climate change whatsoever would be needed. So what about the courts? Are they simply unsuitable? Well, as the critical legal studies movement has taught us, the idea that courts are mere technical appliers and not law creators is flawed. But there does remain a truth in this view of the courts as interpreters of the law, not law creators, in viewing the courts as an ideal type in that sense, is perhaps still worth doing, even if we question the notion that there isn't any politics in the courtroom. And we can recognise that ideal type, even if in every case, no matter how grand or minor its societal consequences are perceived to be, every case involves an element of the political. So in the face of the increasing complexity of the law and the science and climate change, what I aim to do today is to examine the turn to human rights and the criminal law in the context of the two simple questions that I identified, because they serve as a reminder of what's really important if the aim is to actually prevent the catastrophic consequences of climate change. So this is in two parts. I'm going to offer first a very, very quick survey of some, I say recent, but really recent-ish developments in human rights and the criminal law in the climate context. And some of these things are not recent at all, actually. And then offer some critical thoughts as to the effectiveness of those two things, so the human rights law, human rights movement, and the idea of prosecution as a mechanism for climate justice. So first, Very quick survey of recent-ish developments. First of all, human rights, domestic context. I can't stand here and tell you anything about this without mentioning the Agenda case, which you're no doubt all familiar with. It's important when thinking about the significance of Agenda, and I'm going to say some things which suggest that it's perhaps less successful in terms of the two questions that I identified than it might appear at first glance. But that's not to say that I'm suggesting that it's unimportant. It is of profound importance, and its importance lies in how to distinguish it from the multitudes of climate litigation at the global level. When you look at cases which are identified as being about climate justice in one way or another, very large numbers of them are what I would call process cases. So they're about whether or not particular risk assessments have been done, whether or not particular procedures which are already in domestic law have been lived up to. Those things are important strategically, but it's process, and those things are not about meeting the overall limit. So the best known piece of climate change litigation, as I've said, is Agenda, in which a Dutch environmental group and 900 citizens sued the Dutch government to require it to do more to prevent global climate change. And the District Court in The Hague ordered the Dutch state to limit its greenhouse gas emissions to 25% below 1990 levels by 2020, and it found the government's existing pledge to reduce emissions by 17% insufficient. The court concluded the state has a duty to take climate change mitigation measures due to the severity of the consequences of climate change and the great risk of climate change occurring. Now, it's important that there's a panoply of different legal bases for this decision, including the Dutch constitution as well as EU emissions reduction targets, but also the European Convention on Human Rights. In addition to that, the no harm principle, the doctrine of hazardous negligence, principle of fairness, precautionary principle, lots of things. Now, the court didn't specify how the government should meet the reduction mandate, but did offer several suggestions, including emissions trading or tax measures. And it's important that this was the first decision by any court in the world ordering the state to limit greenhouse gas emissions for reasons other than statutory mandates. Court of Appeal upheld the District Court's ruling with some tweaks, again saying that the Netherlands was in breach of Article 2 and Article 8 of the ECHR, and in end of 2019 the Supreme Court upheld that decision. So, all very well so far. I'm going to come back to Agenda. On the international level, on the 26th of November 2020, an association of senior women called the Senior Women for Climate Protection Switzerland took the Swiss government to the European Court of Human Rights because their health is threatened by heat waves made worse by the climate crisis. There were three main complaints: that Switzerland's climate policies violate their right to life and health under Articles 2 and 8, that the domestic courts rejected their case arbitrarily in violation of Article 6. As with Duarte Agostinho, the Chamber relinquished the case to the Grand Chamber, indicating its significance, and the hearing was held in that case in March 2023. After the hearings had been held in all three of the climate cases, the European Court on the 9th of April 2024 found violation of Article 8 and Article 6. Found that Article 8 of the Convention, which is the right to private and family life, includes a right to effective protection by state authorities from the serious adverse effects of climate change on lives, health, well-being and quality of life. It found that Switzerland failed to comply with its positive obligations concerning climate change, with critical gaps in establishing a domestic regulatory framework. And it had also found that it failed to meet its past greenhouse gas emission reduction target. Now, it recognised that national authorities enjoy wide discretion concerning the implementation of climate measures, but held that the Swiss authorities had not acted in time and in an appropriate way to devise and implement legislation measures in that case. Also found that Article 6 applied to the complaint concerning the effective implementation of mitigation measures under domestic law. So, all extremely important, and nothing that I would say and will say about these things seeks to undermine the importance of these cases. They are incredibly groundbreaking, and hats off to the lawyers who put them together. But before I move on to trying to put them into context of the two questions that I identified at the beginning, now I need to address the question in relation to crime. So this is a slightly different flavour, because with crime, it's not so much regulatory in terms of purporting to respond to everything which would breach the standard that applies as a matter of civil regulation, but rather crime inherently is about responding to behaviour which is so bad that we understand it to have a moral element to it. So in theory, crime as a regulatory mechanism is aimed at those who cause particularly egregious harm. But there is an increased interest in it and focus on it at both the domestic and the international level. You will no doubt have heard of the End Ecocide campaign, and it describes itself as seeking to add a new crime to international criminal law. And this would be the first to be adopted since 1945. It would build on the existing crime of severe damage to the environment during armed conflict, whilst reflecting the fact that today most severe environmental damage occurs during times of peace, a situation that they identify as falling outside of the jurisdiction of the ICC. They say that this definition of ecocide, although there isn't a definition there, I would emphasise, offers the states parties to the Rome Statute the opportunity to meet current challenges. They go on to argue that agreeing a crime of ecocide could contribute to a change of consciousness in support of a new direction, and one that enhances the protection of the environment. Now, I can't identify any cases here precisely because this isn't the crime in the Rome Statute. But it's a development, and it's an important one in the question of how strategically climate justice is pursued at the international level. But at the domestic level, the question of crime is also one that is increasingly part of the discourse. And there was an article published, I think a couple of years ago now, maybe last year, by David Arkush and Donald Bramman in the Harvard International Law Review, called Climate Homicide, Prosecuting Big Oil for Climate Deaths. And it refers to a wealth of background research and seems to make a compelling case for criminal prosecution of fossil fuel companies within the American jurisdiction. And I note in particular an observation that fossil fuel companies are being sued in multiple states, for fraud and racketeering relating to a campaign of false statements undertaken as what is often referred to as greenwashing. So you have this impulse, human rights, crime. How useful are these things in restricting global temperature increase to 1.5, to answering the first question and the second question that I identified earlier? So, human rights first of all, back to Agenda. I've said already that the Agenda case is rightly celebrated as groundbreaking, profoundly important, but the court opted for the lowest end of the equity range, and an equity range is a range of potential measures which meet a number of different versions of how to answer the second question that I identified, how to divide up responsibilities. The Dutch Supreme Court said the courts can assess whether the measures taken by the state are too little in view of what is clearly the lower limit of its share. Now, to put that into context, the EU as a whole is on course to reduce its emissions by the same amount within a few years. And on that basis, campaigners and scientists have been saying since before the Agenda decision that the EU's reductions are not adequate. And if every court were to opt for the absolute minimum, which is what was mandated by the Dutch Supreme Court, the collective outcome would be in flagrant breach and beyond the 1.5 limit. The problem is that domestic courts have so far afforded governments significant latitude around this question. So even the most groundbreaking of domestic cases causes a problem in the context of the second of the two questions that I identified. So to emphasise again, first question is, what is the limit? Now we take that perhaps as the 1.5 degrees limit, and that's put into some jeopardy perhaps by the question of tipping points, and also the fact that the 1.5 degree limit would itself be arguably harmful. But there isn't any consensus or any kind of agreement whatsoever on how to divide up those obligations. And when the domestic courts are faced with that challenge, they take the range of potential approaches to burden sharing and allow the state to carry on with whichever interpretation would give it the most breathing room. Now we can see what the obvious problem with that is, which is that every state did that. We'd be in a catastrophic situation by the end of the century. So, how about the cases in the ECHR? Now, I do want to emphasise a number of incredibly helpful and important developments that came from the Klimer-Senioren case, so the case against Switzerland in the ECHR. And for those who aren't aware, that was the only one of the 3 climate cases which was successful. Our own Duarte Agostinho was not, and it was found to be inadmissible on the basis of an impermissible interpretation of the admissibility requirement of jurisdiction. I'm going to come back to what may have been going on in the background there, but I want to emphasise the more important point, which is what was useful in the Klimer-Senioren case. So, the court found that the particularity of the issue of causation became more accentuated in the climate change context, that the causal link between actor emissions on behalf of state authorities in one country and the harm or risk of harm arising there was necessarily more tenuous and indirect compared to that in the context of local sources of harmful pollution. And this was part of the court's helpful recognition of the difference between climate change and environmental harm generally, the acknowledgement of the distinction that I drew earlier, which arises from the fact that you simply can't trace harm to an emitter because it is done through gas. Furthermore, from the perspective of human rights, the court found that the essence of state duties in the context of climate change related to the reduction of the risks of harm for individuals, and conversely, in performance of those duties, those duties entails an aggravation of the risks involved, although the individual exposure to such risks would vary in terms of type, severity and imminence, depending on a range of circumstances. So the issues of individual victim status, or the specific content of state obligations, the court acknowledged, couldn't be determined on the basis of a strict sine qua non approach. So there's a recognition here, we've got some hope, there's flexibility, a willingness to allow states, to not to allow states to get away with it on the basis of the obvious uncertainty around causation that arises in the context of climate change. And on the issue of the proportion of state responsibility, the court found that while climate change was a global phenomenon, which should be addressed at the global level by the community of states, the global climate regime established under the UNFCCC and under other international instruments rested on the principle of common but differentiated responsibilities and the respective capabilities of states. So each state had its own share of responsibilities to take measures to tackle climate change, and the taking of those measures was determined by the state's own capabilities rather than by any particular action or omission of another state. So again, hinting at something useful here, hinting at the idea that something distinct would be done about the question of causation, and perhaps allowing for a way through which doesn't fall victim to the arguable flaws of the Agenda Supreme Court decision. Furthermore, in terms of the, you can imagine what I mean by the drop in the ocean argument, so the idea that no state can do enough to make a difference. The court found that the relevant test didn't require it to be shown that but for the failing or omission of the authorities in the state concerned, the harm wouldn't have occurred. Rather, the court found that what was important and sufficient to engage the responsibility of the state was that reasonable measures, which the domestic courts failed to take, could have had a real prospect of altering the outcome or mitigating the harm. It's very different from the approach to victim status in other contexts. And in the context of climate change, that principle should be understood in light of the UNFCCC, according to which states should take measures to anticipate, prevent or minimise the causes of climate change and mitigate its effects. So all very good. I won't go through the points about the margin of appreciation, but the approach taken to breach was this, that the court emphasised that in finding Switzerland in breach, that there were lacunae in the Swiss authorities' processes, remember that word from before, of putting in place the relevant domestic regulatory framework, including a failure by them to quantify through a carbon budget or any other mechanism a national emission limitation. And as recognised by the authorities, the state had failed to meet its past reduction targets, again, self-determined targets. The authorities had failed to act in good time in an appropriate and consistent manner in relation to devising, development and implementation of relevant legislative and administrative frameworks. So all of this to say, the state had exceeded its margin of appreciation. Margin of appreciation. Exactly what was going on in the Dutch Supreme Court when it allowed the state to be acting in a manner that was compliant with domestic law on the basis of its lowest possible attainment. Now, so what we have here is much progress. I've identified some aspects of the case that should be ground for positivity, but no hard edge, no way of applying the 1.5 limit directly. Excuse me. And to the extent that the court found breach, which is of huge significance, as is its attributions to the European Convention on Human Rights at the regional level, the breach arises from existing obligations being traced back to the Paris Agreement. And again, the Paris Agreement was part of the problem here, not part of the solution. So, what happened with our case? Well, the linchpin to our application, Duarte Agostinho, as it was initially advanced, was that because each of the respondent states, and I should say here that this was a case against essentially as many states as we could get a hold of, so we're completely different from the Switzerland case, which against one state went up to the domestic courts. Our case was one where we started against every single Council of Europe state. We took out a few based on the war in Ukraine, and then on the fact that took out the smallest emitters and some of the smallest populations. But essentially, we were looking to get a hold of as many states as we possibly could. And this was a strategic choice. And it's precisely because that the case was driven by a concept of shared responsibility, which the idea was that the problem of burden sharing is and should be the state's problem. Now, let me just explain that. So the linchpin to the application, as it was initially made, was that because each of all of these states contribute to global emissions, they have to be presumed responsible for the harm and the risk that climate change at its current trajectory was posing to the applicants being a group of young people from Portugal. And those young people face the possibility of having to see 4 degrees of global warming, the effect of which will flagrantly breach several of their ECHR rights. Now, I should say that many of the press conferences in this case came about through this idea that, or there were questions put, in which, and I understand why, the concept of strategic litigation is often one that puts the lawyers before their clients, and that is not something that should ever happen. And understandably, members of the press were raising questions about whether this was really a campaign effort and we were misusing a group of Portuguese young people in order to set about achieving the aims of an NGO or of another set of campaigners. Now, let me be clear about this. When GLAN was set up, it was and this is the organisation that ran the case, it was in its infancy, and there was a group of us sitting in Garden Court chambers one summer when a research assistant who had worked very hard for us over the previous 6 months on a number of different cases, who was Portuguese, came back from her summer break extremely upset and had seen wildfires within reach of her home, her family's homes and her friends' homes. And without going through the long and short of what she said and what she had to say, the emotion that drove that continued to drive it right through until the end. The group of kids who did this were unbelievable in their wherewithal and their courage to pursue this. And it was born out of genuine fear. It was a case which was entirely led by them. Now, this approach, which puts states, we would have said rightly, in the position of having to extricate themselves from a position of presumed liability. So when the science shows that the world at large is on course for temperatures that would have breached their rights, we argued, at least at the outset, that the onus of showing how a given state's activities are lawful falls on them. The problem of climate change doesn't go away when one state blames another through conflicting, self-serving accounts of equity and burden sharing. So one of the effects of this, we argued, was to require that any ambiguity around the meaning of a state's fair share, or its burden, should have been resolved in favour of the applicants. And that argument was based on a general principle of law that where there exists causal uncertainty as a result of the existence of multiple potential contributors to a particular harm, then the victim should, in simple terms, get the benefit of the doubt. And this is not controversial. Principles of that type reappear across legal systems of the world, in common law adversarial systems as much as in civil law inquisitorial systems, and actually in criminal law as much as in private law. And the principle has also been recognised as a general principle of law for the purposes of Article 38 of the ICJ. So as part of the case theory, closely related to that was that where a number of persons, in other words in this situation a number of states, engage in conduct which is attributable to each of them separately, but which contributes to the indivisible injury of another person, then the contributors share responsibility for that injury. And that idea as well can be seen replicated across legal systems and traditions. And, importantly, this is the concept of shared responsibility as a matter of international law. And if that is of as much interest as I would suggest it should be, I would draw your attention to some work done at the University of Amsterdam on the concept of shared responsibility and its customary status. Their work concluded with some draft principles which were published in the European Journal at around the same time as we were advancing our case, and very happily the principles that they identify as a matter of custom were very, very close to, if not identical to, those that I identified a few minutes ago. Now, when we look at the commentary around shared responsibility, it's perhaps only because of the realpolitik of state power that there have been few, if any, clear applications of those principles to states. And James Crawford would always argue in this context that as much as you can argue that particular cases are examples of the shared responsibility of states, all of the decided cases happen to be also ones that you can explain coherently on the basis of individual responsibility of states as well as shared responsibility. Now, I've given a long explanation for that, and that's because this case theory was essentially to our minds, the only way to deal with the uncertainty around burden sharing. Likewise, the idea of pursuing multiple states at a particular time. We can't fix the fact that the Paris Agreement, nor anywhere else in multilateral state negotiations, have managed to share the burden among the states. But the idea behind a case like this is, so what you have, I should say, in terms of this difficulty with the Paris Agreement process and with multilateral negotiation generally, is the fact that there is no global government, and nor should there be, for lots of other reasons. But there isn't an overarching edifice which can decide what is the correct approach to burden sharing, and therefore what is the actual fair share of a given state. So this case theory was advanced with the idea of the global government as a Cheshire cat. So one that appears momentarily in the form of shared responsibility and then disappears, while shortly after the judges have said that the cases are, the states have presumptive liability. It's then on them. The idea was it would be on them through the domestic courts to meet that burden. However, the case was found inadmissible after all that work on the basis of basically one sentence, that it was inappropriately invoking extraterritorial jurisdiction. Now, I don't have time to go through why I would say the court missed the point on that, and nor should you care, because they're judges and I'm not, but even if I tried to do that, it would perhaps be to miss the point. The case had actually evolved from one which was confidently and squarely rooted in shared responsibility into one which included a framework which would allow for the judges to say, actually, this is being decided on the basis of individual responsibility. I take responsibility for that, but so should the rest of the team. But in fact, it's hard to see what was wrong about that in hindsight. The process of arguing the case from the initial application, where it was put in fairly pure conceptual terms, then goes through an unbelievably lengthy process of us responding through rounds of written argument to the way that the objections of this multiplicity of impressive lawyers instructed by governments all over the world, what they've got to say about why what we're saying is so profoundly ridiculous and wrong. Now, it would have been insane, perhaps, to walk into the courtroom just saying, no, you don't need to worry about any of that, because this is about shared responsibility. And yeah, that's right, there hasn't been a shared responsibility case decided today, but you should. However, it's fair to say, I think, that, and I'm not going to go through the nuts and bolts of the reasoning here, but the particular way that the court got rid of the case, it wouldn't have been able to do that if the case had been advanced squarely on shared responsibility grounds. I think that if that was the case, then the concept of the share of responsibility would have meant that the applicants were always and necessarily within the relevant territory, because it was a shared territory for that purpose. And the relevant act was one for which their own government was responsible. It wouldn't have involved extraterritorial jurisdiction at all. Now, would the case have been different if it forced home the shared responsibility point in that way? Well, we will never know. So we have an important progression through the Plymouth-Signoran case in what the European Court of Human Rights was willing to do with climate change as a human rights obligation. But after that fact, we've got the question of compliance. And a matter of 2 weeks ago, on the 6th of March, the Committee of Ministers of the Council of Europe decided that Switzerland is not yet complying with the requirements of the judgment. Switzerland has yet to prove that it's doing enough to align its policy with a maximum global warming limit of 1.5 degrees. And the Committee of Ministers invited the authorities to further demonstrate the methodology used to develop and implement the relevant legislative and administrative framework, responds to the convention requirements as detailed by the court, relying on a quantification, although through carbon budget or otherwise, of national greenhouse gas emissions limitations. So even though Switzerland is just being asked to live up to its own pre-existing duties, it still hasn't. So there's some analysis of where we've reached in terms of regional human rights mechanisms. I realise I've already been talking for quite a while, but I do want to go back to the question of crime, because what I hope you've seen, despite the incredible effectiveness and success of Greenpeace in advancing the Plymouth-Signoran case, is that there are real flaws here, and there isn't any real justice, at least as yet. So what about the narrower concept of crime? What about the idea that you could just go after the worst? Cleaner, perhaps less dependent on the uncertainty of state obligations? Well, the first question is, do we need ecocide at all if we're looking at the international level? The campaign in favour of ecocide seems to suggest that what we need is an amendment to the statute, and if there wasn't an amendment to the road statute, then the prosecutor would be going all guns blazing after environmental harm. But is that really the case? It's true that the precursors to the road statute, under the auspices of the International Law Commission, did include as proposed offences acts causing serious damage to the environment, and that wasn't included in the final statute. So that seems to suggest maybe a statutory amendment is what we need. For what it's worth, though, I think that environmental damage is squarely and clearly already within the Rome Statute, and not only in the one provision that mentions environmental harm. I actually would suggest that environmental justice can be pursued in the context of genocide, crimes against humanity, war crimes, and aggression. I'm not going to go through them all, don't worry, nor the 10 war crimes that I think have a potential environmental element. But none of those things involve the concept of ecocide. So just to give an example, genocide. Article 6 provides the crime of genocide, which is defined as any one or more of 5 acts when they're committed with intent to destroy, in whole or in part, a national, ethnical, racial or religious group as such. Now, at least the acts indicated in 3 of those paragraphs could involve environmental damage, and perhaps the most obviously applicable one is the one in paragraph C of the statute, which is deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. That sounds perhaps a bit too immediate for environmental harm, but the travaux preparatoires to the Genocide Convention indicated that the relevant conditions of life include circumstances that would lead to a slow death. Now, if not that, what is happening in the world? And just to emphasise the point that environmental harm was already within the Rome Statute, the Office of the Prosecutor is in the process of drafting a policy on environmental crimes under the Rome Statute, which itself notes that genocide can be committed through environmental damage, illegal exploitation of natural resources, or legal dispossession of land if the acts in question deprive the affected group of the means of their survival. And the ICCY Appeals Chamber in the Ptolemy case said that acts meeting the threshold of genocide typically relate to the deliberate withholding or taking away of the basic necessities of life over an extended period of time. Now, such acts, I would suggest, could include those which cause environmental harm, where the effect of that harm is to deny persons the basic necessities of life over an extended period of time. And this is not just my own idea. In the Darfur situation as early as 2008, the ICC prosecutor charged Omar al-Bashir with genocide, and the impugned acts included deliberate destruction of the environment by systematically destroying properties, vegetation, water sources, and deliberately destroying, polluting, or poisoning communal wells or other communal water sources by the militia and Janjaweed in Darfur. So, genocide covers the environmental harms. Crimes against humanity. Now, Article 7 of the statute provides a definition of that, which is one of 11 acts which are set out in Article 7(1)(a) to k, where they're committed as part of a widespread or systematic attack directed against any civil population with knowledge of the attack. And they're not confined to armed conflict. Recall what the campaign in favour of ecocide had to say about that. Now, it's important to say also the possibility of a crime against humanity conviction for environmental harm doesn't require that the attack to which the general requirements related involves environmental harm. And the Office of the Prosecutor's draft policy about this says that environmental damage, illegal exploitation of natural resources, and dispossession of land may contribute to a widespread or systematic attack. And again, in the Darfur situation, the basis for crimes against humanity charged included deliberate destruction of the environment by systematically destroying vegetation and water sources and repeatedly destroying, polluting, or poisoning communal wells or other communal water sources. Now, moving on to the specific acts which could constitute a crime against humanity. Again, there are many examples here, but one is the crime of extermination, of which the definition is of killing either directly or indirectly one or more persons, including by inflicting conditions of life calculated to bring about the destruction of part of the population. Now, the draft policy, a different draft policy this time, on cultural heritage of the ICC prosecutor says that when the survival and cultural heritage of members of a group are intricately linked to and depend upon their territory, including certain natural formations, attacks that make the territory uninhabitable may be acts of extermination. And it refers to a finding of the Inter-American Court of Human Rights that depriving indigenous communities of their access to ancestral territory exposes them to precarious and inhuman living conditions, to greater vulnerability to disease and epidemics, and subjects them to situations of extreme lack of protection. So, all these policies, and some of them have been in place for 10 years, seem to indicate a willingness on behalf of the ICC prosecutor to view environmental harm as constitutive of a crime against humanity, provided the effect is to make territory uninhabitable. I'm not going to cite too much more of a statute at you, but it's also worth mentioning war crimes here. And there's a multiplicity of war crimes which involve environmental harm. Only one that mentions the environment explicitly, I would say 10 of the listed war crimes can be a response to environmental harm. But the one under Article 8 2b4, which is excessive incidental death, injury or damage, is made out simply where an attack is carried out, and that attack is such that it would cause incidental death or injury to civilians or damage to civilian objects or widespread, long-term, severe damage to the natural environment, and that such death or injury or damage would be of such an extent as to be clearly excessive in relation to the military advantage anticipated. Now, the Office of the Prosecutor's policy says that the Office will charge violations of that provision when appropriate, taking into account the fragile state of the environment and relying on the best available scientific knowledge when determining whether environmental damage caused by an attack qualifies as widespread, long-term and severe. Now that's a phrase which has its roots in one of the additional protocols to the Geneva Conventions, which has customary status. But it's fair to say that the meaning of widespread, long-term and severe damage is uncertain. Now, whilst that may be seen to limit the utility of that particular war crime in the context of dealing with environmental harm, that meaning could just as easily be clarified by a prosecutorial policy, as has been a number of other things which have been. And doing that would undoubtedly assist and would do so provided the approach taken to that clarification was attentive to contemporary understandings of the significance of environmental damage, including perhaps those that motivate the Stop Ecocide campaign. So, this prosecutorial policy paper, which is from 2016, indicates a willingness to take environmental damage into account in the context of prosecutorial discretion. I'm not going to read the whole of the relevant passage, but it includes the following. The manner of commission of the crimes may be assessed in light of, among other things, crimes committed by means of or resulting in the destruction of the environment. So, whilst the language in this part of the policy seems to appear to indicate readiness and willingness on the prosecutor's behalf to pursue prosecutions for environmental harm, I'm not aware, and there is no, at least that have been found with any extensive research, any indictment at all over the 9-year period since that policy was published alleging environmental damage. And there certainly hasn't been any prosecution concerning the environment on the basis of Article 8(2)(b)(4) to date. So, is a crime of ecocide necessary? Now, the campaign would say that, it raises questions which I would say are both legal and strategic in nature. Now, some of those considerations relate to the benefits of criminalisation as a means of protecting the environment in general. And whilst criminal law is clearly a useful tool, I think it would be a mistake to suggest that prosecution will offer a meaningful response to environmental destruction by itself, not least as a focus on individual responsibility risks diverting energy away from systemic changes which are essential to protecting and repairing the natural world. The question isn't really about the benefits of criminal prosecution as a strategy compared to other strategies for protecting the environment. It's how best to pursue environmental justice within the confines of criminal prosecution as it exists, as a concept. So, let's keep at the forefront of our minds the reality that there remains only a few years to dramatically reduce climate pollution from the use of fossil fuels and deforestation, to keep global average temperature rises to 1.5 degrees. Also, let's bear in mind the introduction of a new crime in the Rome Statute is a fraught and lengthy process which would be delayed by the self-interest of states. Now, it's clear, I think, that many acts causing large-scale environmental destruction, such as those being perpetrated in current conflicts in both Europe and the Middle East, are already crimes under international law and should be investigated and prosecuted now, without waiting years for new laws to be enacted. There's nothing to prevent the prosecution for environmental harm on the basis of these existing provisions, as I've hinted at, And it wouldn't take enactment of a new crime of ecocide to make this possible. So in this context, I'd suggest it's really far from clear what would be gained by advocating for amendment of the Rome Statute to include ecocide. And there may be a disadvantage to doing that. So it's possible, for example, that defendants could argue that the arguments of those, they could invoke the very arguments of those campaigning for the enactment of a crime of ecocide to say that the Rome Statute as it stands was never intended to encompass activity that does harm to the environment, because you need a crime of ecocide for that to be pursued. So before moving on, it's worth emphasising that neither ecocide nor the existing provisions that I've mentioned relate to climate change and emissions per se. And I think there's perhaps a deeper problem in terms of the use of the criminal law in order to try to address the two questions that I identified at the outset and to pursue justice in their name. Now, I mentioned that Harvard Law Review article and the reference to a number of forms of civil litigation in the US. Now, looking at whether or not this could be pursued in the UK, could we prosecute a fossil fuel company for homicide in the UK? Well, the relevant statute is the Corporate Manslaughter and Corporate Homicide Act 2007, creates a criminal offence of corporate manslaughter, and it was introduced to remove barriers to the prosecution of large organisations where a corporate management failing has led to a death. And broadly speaking, its effect is to impose criminal liability on an organisation where the way its acts are managed or organised causes death, and where this amounts to a gross breach of a relevant duty of care by the organisation to the deceased. It replaces the previous law of involuntary manslaughter, and importantly, it abolishes the identification principle. And this is really important here, because that required the concept of a directing mind. So it required, in order for there to be any criminal liability on behalf of a corporation, there to be an individual at the very top of the company who could be said to embody the company in his or her actions and decisions, and they were therefore personally guilty of manslaughter. Now, one of the effects of the identification principle was to create a barrier to prosecution of large companies, and in general only smaller companies with hands-on directors have been convicted of corporate manslaughter. In contrast with the identification principle, the new statute allows for criminality to arise from the management and adequacy of systems. Now, without going through every one of the elements of that crime, a key challenge to it, which I've already alluded to, is the requirement of proving causation and gross breach of a duty. And when we're looking for a model for where a duty of care can be identified, you start to look around the world for where a breach has been found. And in that context, the question isn't so much whether or not fossil fuel companies might be found to owe the public a duty of care. You can establish that through policy and through regulation, but rather what the approach should be to determining whether any duty was breached. And here we're back to the same problem. The key difficulty is in specifying the content of the duty. What level of greenhouse gas emissions would be allowed without breaching the duty of care? Now, it's plainly wrong to suggest that emission of greenhouse gases per se either causes death or would be in breach of a duty that could sustain a prosecution. So what kind of models could we look for? And this is the last point that I'm going to make on sort of straightforward black letter law type stuff. But there was an incredibly important case, again in the Netherlands, called Milieu Defensie and others, against Royal Dutch Shell, which was also heard before the District Court of The Hague. Now, this is one of the most important cases in the context of tort, because it's the only one to date in which a court has found a breach of a duty of care on the basis of the extent of its production of fossil fuels. And it ordered that Shell should cut its global CO2 emissions by 45% by 2030 compared to its 2019 levels. This was the first time a court had made a specific mitigation obligation on a private company over and above reduction targets set by existing regulations. They're called cap and trade regulations. I won't probably bore you with the details of that. However, when we look at the way in which this duty was formulated, now some aspects of it are straightforwardly aspects of Dutch law, but if we're looking to use this as a way of formulating a duty of care outside of the framework of what's permissible as a matter of regulation in domestic law, there are some aspects of it which even cause problems at that level. So the court tried to determine the content of Shell's duty on the basis of what it referred to as widely accepted soft law instruments, including the UN Guiding Principles on Business and Human Rights. But looking at those instruments, there isn't anything in them which can actually assist in determining the precise content of the duty. So again, we have no hard edge here, the same problem as we've been faced with throughout. When one looks at the judgment also, the court implicitly assumes that Shell has to reduce its emissions from its global operations at the same pace as global CO2 emissions are projected to decrease. But emissions reductions inevitably unfold differently in various segments of the global economy. So for instance, the largest share of mitigation outcomes up to 2030 is expected to result from huge cuts in coal consumption, whereas natural gas could continue to be used widely as a substitute for more CO2 intensive fuels. And last, the court chose a mitigation pathway. I should say that mitigation pathways are particular ways, that they're methodologies which have been produced by the IPCC in order to provide an understanding over time of what would amount to compliance with the 1.5 degree limit. And the court chose, and there are a number of different mitigation pathways that the IPCC has set out. Now the court in the Netherlands chose a mitigation pathway that assumes a particular reduction in CO2 emissions by 2030 compared with 2010. And it says that this projection would lead to a 50% chance of limiting global warming to 1.5 and an 85% of limiting it to 2 degrees. However, the judgment contains no justification at all of its selection of that particular emissions pathway over any other. And there are a number of others which are also consistent with a plausible interpretation of those temperature targets. So, there's nothing there either which can provide us with any kind of hard-edged duty. So this is my concluding comment. All of this may seem to indicate doom and gloom. Now that is not my intention. The aim here is to encourage a critical mindset and not to see the law and the courts as a panacea. Indeed, if we step away from a straightforwardly legal mindset and consider the mere fact of the huge growth in climate-related litigation as a social fact in itself, then perhaps the inherent benefits of those processes come into view. In many ways, surrounding and within the courts, across all of the many forms of litigation that have happened to date, are conversations and sharing of learning which would have never happened otherwise. You know, the 3 advisory opinions before various international fora, the Inter-American Court of Human Rights, the International Tribunal on the Law of the Sea, and perhaps most importantly, the International Court of Justice. And I haven't spoken to those because we have an expert in the room and a representative on those cases. But those cases have provided a political forum which is perhaps akin to a multilateral treaty negotiation in some ways, with perhaps the additional benefit of putting states in a position of very slightly greater jeopardy because it's not they who are ultimately calling the shots. This dialectic feature of litigation is where I think the hope lies. The question is, how quickly can it make a difference? That's all.